was denied. Relief was denied. The only court orders enacted at this point in time are the one awarding dad to have joint residential custody, Your Honor. So, Your Honor, she was free to file an emergency motion with this court. She was free to file the PFA. She was free to file an investigation with DCF, which has been investigated to dad's knowledge. What she was not free to do was appoint herself as a judge. She could not simply decide, I believe there's a safety concern, therefore the existing parenting plan no longer applies. Your Honor, again, they submitted a video for this court to consider. We have watched the video, and he says in the video, he sits there apologetically and says, hey, I had no way of knowing it would happen again. I thought I handled it. I thought I put all the safeguards, and it hasn't happened again in his household. It happened again in petitioner's household. And granted, had he advised her, would she have not left the children unattended? Absolutely. But to his understanding, this has never happened before. It never happened before. He's always had joint residential custody for all of the child's life. He has never witnessed a similar incident with his child. He had no way of knowing that it would continue to happen. He had no way of knowing that this event would trickle down to the July event with Ms. Dunn's child. So in the video that was presented for evidence before this court, Dad was attempting to de-escalate. He said he took full accountability of the fact that he should have let mom know. It was a poor lack of judgment, and I think this court would agree. He immediately acknowledged the fact that the child needs to go to therapy. He acquiesced to whatever he needed to facilitate that. And he contacted law enforcement whenever she deprived parenting time, Your Honor. So here Dad has tried to do everything to de-escalate and try to do everything to prevent this situation from happening again. Your Honor, this was a, for lack of a better word, a tragedy that happened, and that happened again in July. He takes full responsibility for his poor lack of judgment of not contacting mom. But he used his judgment. He thought that he was acting within his, right as a parent. He pulled them to the side, and he thought he handled the situation. And Your Honor, this demonstrates his willingness to act in the best interest of the minor child, Your Honor. We have submitted text messages and Respondent's Exhibit G of petitioner refusing parenting time. Almost every single day since July 22nd, he has reached out and said, hey, I need to see my daughter. She needs to see her father. What's going on? Why can't I see her? She's been unilaterally refusing to exchange the minor child. She knows that the safeguards are in place where neither child is going to be left alone. And quite frankly, the child shouldn't be left alone with other children in either home, pursuant to the accident that happened with Ms. Dunn's child. And that's not good enough for her, Your Honor. So really, we're asking for this court to reinstate his parenting time and to acknowledge the fact that it's in the child's best interest to have meaningful relationships with two parents. This has been a traumatic event with the child. She's now seeing a therapist. She's been yanked apart for the status quo of her having meaningful parenting time with each parent. Now she's in therapy. This has shifted her whole world. We strongly believe that it's in a child's best interest to have respondent's parenting time restored. Your Honor, if the court has any continuing concerns about interactions between the minor child and his stepchild while the investigation occurs, he is prepared to abide by reasonable safeguards, the same safeguards he has already implemented, that the court can order that the children remain separated. The court can require separate sleeping arrangements, which is already implemented. the court can prohibit unsupervised contact between the minor child and the other minor child, which again is something already implemented. But none of those measures require depriving the minor child from time with her dad. There's less restrictive solutions available, and respondent has demonstrated his willingness to implement it. Your Honor, so to wrap up, respondent is not asking this court to ignore what happened. He's asking the court to look at what he did when he learned about it.
The judge starts from a position neither side can comfortably claim as a victory. He questions whether dad's lost parenting time created a true emergency, while also recognizing that mom may have faced a legitimate safety concern.
These are two young children, 5'7". He acted, he bought separate beds, posed rules, told the child separately, talked to them. Could he have communicated with Haley sooner? Absolutely, he should have. But a failure to communicate is not a failure to protect, and it does not make him a danger to his daughter. Petitioner had concerns. She had every right to report them. She contacted law enforcement, DCF, pursued a PFA. But reporting a concern does not give her the unilateral right to rewrite a court order. And I think that's the fundamental disconnect here, Your Honor. The alleged conduct involved another child, but her solution was to remove father from her daughter's life. Corporate safeguards are justified. Unilateral suspension of father's parenting time is not. And until this court changes its order, the order is not optional, Your Honor. We ask this court to enforce it. Thank you. Nothing further.
Mr. Vasquez, you mentioned earlier as part of one of the options for the court, separating these two children. What did you mean by that?
Separating no unsupervised contact, Your Honor. Separating them. They're already separated in different rooms. There has already been a rule since the October incident that they're not to be unsupervised. That is what respondent meant separate, to continue the separation that's already implemented. But if this court has any other alternatives, Your Honor, he will follow them. He hasn't seen his child since July 22nd, July 17th, I'm sorry. He's willing to abide by any court orders that the court issues here today.
Very well, Mr. Vasquez. At this time, the court will turn to Mr. Kidwell. Your client's position today, Mr. Kidwell?
My client's position, based on facts that were not disclosed during that presentation, is that he should have supervised parenting time. And I want to explain that this is not the first incident. And I want to explain, Mr. Vasquez was talking about the text messages. I'm going to ask the court to go to bait stamp page 23, which was part of the text exchange. And this is between, obviously, my client Haley and Zach. And on bait stamp page 23, Mr. Vasquez was correct. He keeps asking every day to see the child. My client responds, quote, Zach, you have known about this for approximately 10 months. I only learned about it 2 weeks ago because you didn't inform me, despite me being Ember's mother. I have serious concerns for Ember's safety. You took action when Cincinnati was reportedly by his mother's cousin's son, and they no longer have any contact. Why is Ember's safety concerns being treated differently? So the reality is that this behavior has occurred numerous times in Dad's home, and he never reported it because he didn't want to get any
misstatement of facts. That's not correct.
My witness, Miss Dunn, will testify as to every bit of the entire conversations. We also submitted the videos of Zach admitting that this had occurred previously,
and
it had occurred. Yes, they're included in our exhibits. So we obviously there's an issue, and it's a trust issue. You know, he was married to his wife, Gabby, in January of this year.
Dad's attorney now attacks the weakest part of Mom's legal position. She apparently changed the parenting arrangement without first obtaining an order authorizing that change. That gives the defense a powerful argument, because safety concerns and legal authority are separate questions.
And I don't know what the disconnect is here. If something like this happens, especially if kids are just experimenting, that's, you know, the parents get involved and that's what happens. But when these things have happened before, but you don't know anything about it until the 17th, that's a huge, huge problem. And yes, as a matter of fact, my client said we need to get the child into a therapist. That's on Bates Stamp 12, Exhibit 4, that Ember has been receiving services at South Central Mental Health on July 24th. She's participating in outpatient mental health and community-based services to address ongoing emotional and behavioral concerns. She has a diagnosis of F9 1.8, other specified disruptive, impulse control and conduct disorder. She demonstrates functional impairments in multiple areas, including functioning within the home, behaviors towards others, mood regulation, and self-harmful behaviors. So, however long this has been going on, that should have been communicated. And I'm not talking in October of last year. It was happening before then with other kids. And then she finds out.
Your Honor, again, we would object. That's not true. Anything that petitioner knows has been disclosed by respondent himself. That's simply misleading to the court. And we have to object that that's not true. They've only been together for a year and a half. The incidents that happened with another child were prior to him even knowing the child. Therefore, that's just not true.
Mr.
Your Honor.
Kidwell, the floor.
Thank you, Your Honor. We requested that Miss Dunn be present because starting on Bates Stamp page 29, Exhibit 6, it's a very detailed statement as to what was said, who said it, and what was discussed. And I know that you have read this statement. I could ask her to summarize it or read her entire statement in, but she has obviously skin in the game.
Okay, and what significance does this statement have?
That when they went back in the room and Ember was, Gatlin was yelling and crying, trying to get out of the closet. She'd ripped his shirt off. And so when they sat down, meaning my client, the other Haley, the mother of Gatlin, and Ember was very proud of the fact that she was doing this, and she did it quite often, and she didn't understand why any of it was wrong. And it's a very shocking, absolutely shocking, God bless Ember. She's just telling the truth. But she talks about doing this and what she's learned, and she said she likes to do yucky things with other kids and all the things that a child would say, which means, if you would like me to or allow me to question Miss Dunn, then obviously, but she was there when it happened. They were both there, my client and her. And that's what led to all of this, because obviously my client contacted Zach and said, hey, this just happened. And, Amber says this happens, blah, blah, blah. And it's happened before. And I don't understand the logic that it was okay to not disclose that, because now we don't know how many other children have been involved in this, but we do know that Ember.
Dad's side argues that mom did not merely protect the child, she created restrictions that went beyond the existing order, including conditions on parenting time. That framing is designed to make her response look less like temporary protection and more like unilateral control.
Has to have specific therapy now, because it wasn't just a one-time thing. It's been going on. And something has to be done. As I stated, and I respect that Mr. Vasquez objected. My client filed the PFA naming the child Cincinnati, a 6-year-old. She didn't know that she had to name parents, step parents, etc. That's why no orders were issued, and that matter is still set for full discussion. But in the meantime, if you're a parent and you've been deceived, and somebody says, "Well, I'll make it all better now," but then there was a prior action and he didn't allow contact with that family or that kid for a year, why does that make it okay now that he decided to say, well, yeah, that happened, but that doesn't make any sense to me. You as you tell every client, you have a court order, you need to follow it. There's only one exception to that. If you knowingly put your child at risk or in danger, you get charged with felony neglect. That's just the way the law works. So we can try to punish her because she's trying to do every single thing she can to protect their daughter. We're asking for supervised visits. We're asking that we review this after we get to have the PFA hearing, which I've already entered on also. And we go from there. And I obviously need to file an amended with the correct information, because my client is not an attorney and she just named the child. But that's what the reality is. And it is a horrific reality. I'm not envious in any way of you having to sit through this hearing. I'm asking for the relief that he have supervised visits. And whenever the therapist, unless the therapist has already told both parents when they both need to be in there for family therapy, she just started on the 24th, but her recommendation is continued participation in therapy to support progress towards these treatment goals and to promote improved overall functioning. In addition, if additional information is needed, participation, treatment, please contact me, blah, blah, blah. The whole point is to go, as we all know, into family therapy, but a child should be able to speak freely to both parents. And this is where we are because my client made the choice to not be later charged for felony abuse or neglect by returning the child, when there's no way you can possibly have someone at home monitoring these children 24 hours a day. So she knew that she had to make a choice. I was not representing her. I didn't give her any of that advice. I do know this. These circumstances are not a normal thing where kids are trying to experiment, and this is an ongoing pattern, and we need to protect the child. Thank you, Your Honor.
Good. Well, a couple of questions I'd like to ask you. First of all, how do you know why the protection order was denied initially?
My assumption is because she named a 6-year-old boy, and she filled it out, filed it. Obviously, there were no temporary orders issued, and that's why it's set for hearing.
All right,
That's
Mr.
my
Bidwell, let me clarify for the record. It was this court that denied the temporary order. I know
Okay.
why it was denied. One, I think you've touched on, the minor child does not have the capacity to be sued. Number two, there was a substantial limitation on a custodial parent's rights, or at least a shared custodian's rights, without that person being a party to the action.
Mom's attorney changes the battlefield completely. His argument is not simply that something concerning happened. He attacks Dad's reliability as a co-parent. The key issue becomes what Dad knew, when he knew it, and why Mom remained uninformed.
That was the second reason a temporary order wasn't issued in the case. And since the case was not assigned to me, ultimately, this court did not feel comfortable with dismissal and rather allowed the case to proceed further, as the course may be eventually, with the assigned judge, Judge Crum. So I just found it interesting that you were making characterizations about why the order was denied without having actually been there and knowing why it was denied. But the second question, perhaps much more important than the first, Mr. Kidwell, what legal authority is your client relying on for the proposition that she could unilaterally deny parenting time to the father when there was a court order which clearly established his time? Your answer? Did you hear my question?
I'm sorry, Judge. You cut out at the end.
What legal authority did your client have to deny Mr. Rodriguez his court-ordered parenting time?
She was acting in the best interest of the minor child.
And what legal authority are you citing that she can make that determination unilaterally and then enforce it?
I'm not.
Okay. So I think you're making a concession. She didn't have legal authority to do so.
Well, yeah, because every person, every attorney, just like every judge, tells their clients to follow a court order. But I wasn't involved in it, so I couldn't have given her that advice.
That would have been good advice, Mr. Kidwell, without a question.
Thank you.
All right. The real issue before the court, folks, today is I think we know that there were some unfortunate incidents involving children in the past. Where do we go from here? This court does not see that any failure to disclose by Mr. Rodriguez constitutes some forfeiture of his parental rights. It does not. I think the better practice would have been to disclose each and every incident to the other parent. That is the nature of joint and shared custody. Clear communication on anything important, and I can't think of much more things that would be more important than what happened here involving these children and their incidents. It's also clear that the child in this case needs therapeutic intervention. That's already been recognized. It's already been set up. This court will order in this case that this child continue with therapeutic services as recommended by South Central Mental Health Counseling Center, and the parents are both ordered to participate either individually or in joint sessions as directed by the therapist connected with her case. I have had cases in the past where a parent simply did not think it was appropriate or necessary for them to be involved. Not here. Both of you will ultimately be part of the solution for this child and part of any development or healing which is necessary concerning this child. So you need to be very much involved with the therapeutic process to the extent that the professionals recommend. Second of all, I think it's inappropriate to continue to deny the father from having parenting time with the child. There were other workable alternatives. Why not give him a couple of hours at the park, away from this child entirely? There is no evidence before the court that Mr. Rodriguez himself is an actual perpetrator or an actual danger to his child. Therefore, his parenting time should be reinstated immediately. However, certain safeguards need to be in place. Part of these, I think, have already been laid out. It's obvious to the court that these children cannot spend any time together unsupervised by an adult. And I don't know logistically how the household's going to work that out. Are you going to keep an eye on one or both children constantly to enforce this? For a while, the court believes it's necessary, or the other child needs to be removed from the household. But I think that if there is adult supervision, monitoring at all times, whether these two are together privately or not, I think that should be sufficient. Mr. Rodriguez understands the problem. He understands the dangers.
The emotional pressure reaches its highest point here, but emotion alone cannot decide the legal question. Mom's attorney uses the witness account to argue that the behavior may represent a broader pattern rather than a single isolated incident.
If it's not done, so therefore they're sleeping in separate rooms, and I think that their situation needs to be closely monitored by the adult in charge at all times. They are not to play together separately unless the adult's there. It's that simple. Now, there may be some therapeutic recommendations made as part of the process along the way. And I'm not really intending to substitute my judgment for a qualified child therapist about how to manage this situation long term. But for now, there needs to be safeguards in place to make sure that these children simply do not have the opportunity to have this happen again. In either household, for that matter. We've got a child that knows more than she should. So both parents have to be forever vigilant about her acting out on any of these tendencies. It's an unfortunate situation, but I believe both parents need to be actively involved in the solutions to the problem. And simply stating that the father has somehow forfeited his right to his parenting time is not part of the best interest of this child, either in the short term or the long term. All right, so with this pronouncement made, as far as the parenting schedule that's currently in place is concerned, where should the child be? Whose week is it, in other words?
Respondent's week, Your Honor.
Okay, can you just use mother or father and get away from this whole petitioner and respondent thing, which I think is just more confusing than helpful?
Absolutely. It's father's parenting time this week, Your Honor.
All right.
This week?
Or has the schedule been so disrupted that people can't keep track
Well,
of it?
we've been week on, week off. And
They had a 2-2-3 in the 2021.
on the 7th, it's my week.
Starting the 7th of August.
Yes.
Yes.
Okay. But unless I'm mistaken, it's August the 5th.
Yes, so it's his week now.
Okay. I want this child in dad's home tonight. Mr. Rodriguez, are you in a position to be able to take her?
Yes, Your Honor.
Are you in a position to be able to carry out the safeguards which the court has outlined, including strict adult supervision and keeping these two apart unless there's the adult right there to supervise? Are you in a position to
And
be
you've,
able to do that?
Your Honor, you've stated separate rooms, not just separate beds.
That's correct. They need to sleep in separate rooms, even if they need to be temporary accommodations. Children
Your
are
Honor,
quite
they
sleeping
sorry.
rooms. Much
They do
more.
have separate rooms.
All right. That's part of the court's expectations and demands here. If Mr. Rodriguez is in a position to be able to take her tonight, I see no reason why he shouldn't finish out his week. And let's go back to this to the schedule.
Where will you meet
It's in
today?
place.
So I can meet at the police station in Rose Hill.
My client says she can meet him at the police station in Rose Hill today to exchange a
Is that their
child.
normal exchange point?
Huh?
Is that their normal exchange point?
No, I think the normal is he normally picks her up at my house.
Okay.
So
Do you just want him to come and pick her up at the house then?
It'd be easier for the child if he did.
yeah,
Yeah. And what time are you going to do this? It's 20 till 4.
takes me about 40 minutes to get home.
Okay. So by 5? Okay, by 5, Your Honor, if that's okay with Dad.
Rodriguez, 5 o'clock?
That
Haley's
works for
house?
me, yes.
All right, that's when the exchange will be made. You'll keep her for the rest of your normally scheduled work week or visitation week. And I understand that turnover is going to be relatively quick, but I think under the facts and circumstances of this case, it's probably consistent with the best interest of the child. She's been away from your house for a little while. Mr. Rodriguez, you're going to just need to be mindful of that and try to be the most understanding and that you can be with her situation. Hopefully she doesn't really know what's going on in court.
The judge first exposes an unnecessary credibility problem by correcting mom's attorney about why temporary protection was denied. Counsel had offered an assumption about the court's reasoning without actually knowing it.
No.
My
I
client
wouldn't try
has
to
not
discuss it
discussed
with her
anything.
dad. Just let her know that you missed her and that you're glad that she's with you. That seems to be enough. All right. Judge Crum will deal with the protection order in due course, I presume, and make an appropriate final order of some kind when that matter is scheduled to come to court. So with this current set of orders in place, I'm going to need a volunteer to draft the order stemming from today. Mr. Vasquez, you're going to do that?
Yes, Your Honor, absolutely.
Please do. Get that over to Mr. Kidwell as soon as you can, including that reversed exchange time for Friday night. What's the normal exchange time on Friday evening?
Your Honor, it varies
30,
by
I
my
mean, it
work
really just
schedule.
depends when he goes by his work schedule.
My client says they've agreed on 4:30, but they've always done it by whenever his work schedule. So if it's a little before or if it's after that, they've always agreed to that.
Well, let's set a time this time, a little bit later in the evening, Mr. Rodriguez. 6 o'clock?
Yeah, I can do that, yes.
Very well, 6 o'clock, Friday. And I really would admonish the parents to try not to involve the child in the legal proceedings. Just let her be as innocent as she can be under these circumstances. Just let her be a child and enjoy both parents' homes again. But under close, watchful eyes. I just hope there's
Thank you, Your Honor.
All right. All right, counsel, is there a need for any further scheduling in this particular case? Mr. Vasquez?
I don't believe so, Your Honor.
Mr. Kidwell?
No, Your Honor. No, Your Honor.
If you can, counsel, I'd like to see the order stemming from today in the court's queue this week.
Absolutely.
Very well. I appreciate counsel's endeavors in that regard and for your passionate arguments on behalf of your clients here as part of these proceedings. After all, it's the best interest of a child that we're trying to promote here while respecting the constitutional rights of both mother and father to parent. I perceive currently before me, we have two caring parents that love their child, but part of that is working with and communicating with the other parent. Good luck in that regard, because in this case, it's absolutely critical. Very well then. If there's nothing further at this time, this matter will currently be in recess, and this meeting may be ended for all at this time.
Thank you, Judge.
The ruling becomes real the moment the judge checks whose parenting week it is. This is no longer a theoretical discussion about future rights. The court orders the existing schedule back into operation immediately and requires the child to return to dad that night, provided the safeguards can actually be followed. Notice how specific the judge becomes. Separate beds are not enough. Separate rooms are required. Strict adult monitoring is not presented as a suggestion. Those details show that restoring dad's parenting time does not mean the court dismissed the underlying concerns. The judge is restoring parental access while tightening the conditions surrounding it. He also rejects unnecessary drama around the exchange. Instead of turning the handoff into something resembling a law enforcement event, he favors the familiar pickup arrangement because reducing disruption matters for the child. The adults fought the legal battle. The child should not be forced to emotionally carry it. The closing instructions reveal the judge's broader view of what actually failed in this family. The court can impose supervision, set exchange times, require therapy, and clarify sleeping arrangements, but none of those orders can repair communication between two parents who stop trusting each other. The judge deliberately leaves the separate protection order proceeding for the proper court rather than trying to decide everything in one hearing. That keeps this ruling focused. He also tells both parents to keep the child away from the legal conflict, which is crucial after weeks of disruption. The final message is sharper than it sounds. Loving the same child does not excuse either parent from cooperating with the other. Dad's communication failure mattered. Mom's unilateral suspension of parenting time mattered. The court's solution rejects both extremes and puts the responsibility back where it belongs, on both parents to protect the child without turning parental conflict into another source of harm.